All right, so Deputy Laura has just laid down the gauntlet. So for those of you who know, Raymond is out of this discussion because he hasn't seen 16 Candles. So her question, yeah, neither has Scott McCrum. So her question is, 16 Candles are pretty in pink. Oh, there you go.
No, that's.
Breakfast Club. Yeah. The Breakfast Club.
Oh, Breakfast Club.
That's the real one.
The pretty and pink is the one where, just on one side of the tracks.
It's with Spader. Kevin Spade, what's his name? Yes, Spade, right?
Yeah, James Bader's on it.
She wants to make her own dress. Okay, I guess so.
Ducky shows up last minute. Anyway.
And fun note, the book is completely different from the movie.
Oh, really?
Yeah, because in the book, she doesn't end up with the guy she ends up with. They just did that because people in the theater, you know, said, we want her to end up that way. They just don't make great movies like that anymore.
Yeah. Then throw the Breakfast Club in there. Breakfast Club.
Mm-hmm. Okay, here's one for you. Breakfast Club or Fast Times at Richmond High.
Oh.
Now.
Fast Times. Very different movies, but yeah, I gotta go with Fast Times.
All right, John Garza.
Gentle lady.
All right. So what is happening on this case?
Your, may I ask, do you have the family violence or the criminal trial division?
I have the criminal trial division one and also the family violence one. The family violence one, I'll sign that.
Thank you, Your Honor. The criminal trial division is in evading. Defense would request a trial date. There is no offer there is no agreement that we can reach.
All right. How long do y'all expect the trial to last?
2 days.
All right, Ms. Ferguson. Jury trial date, criminal trial division.
Your Honor.
All right, December when? All right, so we'll come back on December 3rd with regards to the dismissal from family violence. They say that the witness is missing. So whatever occurred, you need to make sure that it doesn't occur again. Do you understand?
Yes, ma'am.
All right, so we'll bring you back on your other case for jury trial December 3rd. All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Your Honor.
Thank you.
I'll be trying, I'll see you at that minute. Thank you. Oh, on the motion to remove GPS, are y'all gonna be opposed or? Just to bring it forward? Okay.
You want to address the GPS thing now?
We don't have a motion on file, but if Your Honor would.
Well, you want to
consider-
speak, I think the GPS was related to their case.
Correct, Your Honor. It was added on, when the assault family second case was filed.
All right, so State on Garza. Are you able to contact the complainant to let them know that there's a request for removal of GPS?
John Michael Garza.
We cannot get in touch with her.
All right, so are you going to have any objection to the removal of GPS? Because the GPS is, I believe, because of the family violence case.
We have no objection.
All right. All right, if you'll do the order and I'll sign it. If you want to write one up, you can.
Thank you so much, Your Honor.
You're welcome.
Appreciate that.
Thank you.
Thank you.
And Victoria, if you make sure that you all have an acknowledgement of discovery on Mr. Garza, please.
Yes, Your Honor.
And Norma, what page is Garza on?
Page 3.
All right, thank you. And the second page? Because he has two cases. All right, thank you. Willie Cunningham, who's the attorney for Willie Cunningham? All right, and you're asking for a continuance, why?
Yes, Judge. We had a video that was produced last week that we hadn't seen, and it could affect our negotiations. It definitely could affect our defense strategy. If we were teamed up, still trying this.
All right, are you gonna have any objection to their continuance?
No, Judge, I don't know what video he's referring to, but I trust that he just is reviewing it.
Ashley checked on it when she saw it.
Yes, yes. Yes, we did upload a video.
All right, this is what I'm gonna do on this case. Ms. Ferguson, on Cunningham, can you recall this for November 21st? That's gonna be your final plea deadline date, and then after that time, you're gonna get a jury trial.
Very good. Thank you, Judge.
All right, thank you for addressing appropriately for court.
Thank you.
At 3 o'clock.
All right, who's here on Jesse Arriaga? All right, so you all are up. Are you ready for trial?
No, Judge.
Okay, why not?
There's a subpoena outstanding. We've been trying for the longest time to get a therapist that worked with the child when she was in the St. Peter St. Joseph's.
Mhm.
And they, St. Peter St. Joseph said, we don't know him. He hasn't been here in a long time. Been getting kind of, I won't say they run around, but they really haven't been cooperative. We think we've tracked him down. We've been in touch with the state about this forever, the last 2 or 3 settings.
All right, what are these records related to?
It's not a record, Judge. The child actually worked with this person. And we believe there was conversations with this therapist directly related to her motivations in these allegations. And so we think that person's critical.
All right, state.
We requested records from you guys, but we were represented that they didn't have any leads. We don't know who exactly this person is. Defense actually has the name apparently. I didn't know
Yes.
which person.
I don't think they claimed they don't know him because they never worked there, just that
Oh,
they
okay.
weren't really cooperative with helping us get him into court.
Yeah, I'm not exactly aware of that defense's witness, but we can make attempts if the court would like us to get a hold of this person, but I don't know who this person is. We need to get a name.
All right, do you have the name of the person you can give to the state to
We
see?
do judge and they've had it. I don't know Ray's new in your court, but the person whose hack was working on it, we visited with him several times on it. He did make efforts. But we think she made some suggestions in the therapy that she was trying to remove herself from the home where she was living, where my client was living. And
All right, Norma, on this case, recall it for the 7th.
November 7th?
Yes.
we have issued a new subpoena since we've got the new address judgment. It hasn't been served.
All right. So we're gonna come back on November 7th.
Is that on Monday?
No, that's Thursday.
Thursday.
Yes. All right. Once you sign the reset form, you're excused.
Thank
All
you.
right. Thank you for dressing appropriately for court.
Thank you.
You're welcome.
Domingo?
Selena Leone, come down. Who's the attorney for Selena Leone?
It's, Alfredo, Joseph Alfredo?
Oh, it's in the front.
Okay. Mr. Acevedo. Hi. Ask. All right, just have a seat.
Okay.
Who's here on Domingo Rodriguez? All right, everyone, I need you to whisper. Court is calling 2024 CR 6486 State versus Domingo Rodriguez Jr. Can I have parties announced for the record for the state
Ed Harris, Salem.
defense?
Renee Munoz.
And are you Mr. Rodriguez?
Yes, ma'am.
Are there any applications?
No, Your Honor.
All right. Counsel, have you received all of the discovery?
Yes, Judge.
Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the document entitled True Bill of Indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, waiving the repeater offender enhancement allegation. No objection.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 66 days in the Bexar County Jail under 1244, and there are no applications. Did you understand that to be the plea?
Yes.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
And it needs to go one and attachments, Your Honor.
No objection.
You may be excused.
Thank you, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we respectfully requesting that you follow the negotiated plea bargain agreement. He was cooperative with officers. The minimum amount of controlled substance, we've been in custody for the last 66 days, without the ability to bond out. We're asking that the court, find, 66 days is appropriate sentence for this amount of, controlled substance. And we're requesting if the court sees fit to announce judgment satisfied on the case, Your Honor.
All right. The court will sentence you to 66 days in the Bexar County Jail under 1244, give you any credit for any time served, and the court will find that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. It's obvious that you have a drug issue. You're going to need to take care of that. Otherwise, you're going to find yourself back here in court again. If you have, if you want help, there are plenty of places that are free here. If you feel as though you can't find a place, if you come back to court, I will direct you to a place where someone can help you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Selena Leone. Court is calling 2022 CR 6318, State of Texas versus Selena Leone. Can I have parties announced for the record for the state defense? And are you Miss Leone?
Yes, ma'am.
Counsel, have you received all of the discovery? Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Ms. Leone, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do that.
State, are you proceeding on the indictment as presented?
No, Your Honor, waiving count 1.
Any objections?
No objection.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe she has a rational as well as a factual understanding of the charges against her? Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir.
Ms. Leone, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. They're asking that your punishment be assessed at 6 years in the prison. There are no applications. This will run concurrent with Comal County Cause Number CR 2022 366. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense in count two, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Should be contained in exhibit one and attachments, Your Honor.
No, Judge.
All right, state you may be excused.
Thank you, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes, ma'am.
I need a signature there. And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after viewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, and before the court imposes a sentence, the defendant has been continuously in custody since May of 2022. And has not been out in the free world since May of 2022.
Is that here in Bear County?
She was in Comal County and then got sentenced in Comal and got sentenced to TDC.
TDC, then Floral County.
Sorry, just 1 second. You're whispering and the court reporter is taking down everything that's being said. So you were where?
I was in Kendall County at first, then I went to TDC, bench warrant from TDC to Comal, then went back to TDC.
All right. All right, so with regards to your credit for that time served, you'll receive credit for that time if this case was open. So if there was a warrant for you in this case at that time, you'll get credit for any of that time. The clerks will just need that information. You understand?
Yes, ma'am.
All right, the court is finding you guilty. The court will sentence you to 6 years in the prison, give you credit for any time served. This is the run concurrently with Comal County Pause Number CR 2022366. There's to be no contact with John Anthony Gutierrez. The court will give you credit for any time served in Kendall County, TDC, and Comal County if this case were open during that time frame, and the court will request therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to change your life unless you want to spend the rest of your life in somebody's prison. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you.
You're welcome. All right, you all can get ready to start clearing out the box. And if there's somebody left, we'll have to take them up during a break. And where is Matthew Allen?
They're finishing up closing, I've been told, and they're taking it back on the normal side.
All right.
I just went down to
Deputy
check.
Mejia, they say that they're finishing up closing down there. Okay. We're waiting for Matthew Allen to come back. They're doing sentencing in another court, so they're not ready yet. Yeah. Sorry. Daniel Guerrero.
Sorry, I thought the file was already up there.
Hello. All right, this is family violence. You all are scheduled for trial.
Sure.
All right, we're just waiting to see who's gonna go.
Okay.
All right,
We're just.
just hang around.
Thank you. Thank you.
All right, could I see the file on Richard Casanova? Norma, where is Michael Collins? All right, he has a jury trial. Presiding doesn't take precedent. Norma, recall this case for Thursday. So Deputy Laura, Richard Casanova can go back. Sorry. All right, thank you.
Well, I mean, if
Now I know.
Vital assumptions.
You're set.
Thank you, Judge.
Zayden Ali?
Hi, Judge.
Yes.
My client is currently at the Texas Med Clinic, getting evaluated for a back injury and a possible head injury. He was in a car accident last night. He sent me the incident number that he received.
No, I mean, why is he waiting till today?
Well, so it was last night.
Mhm.
He refused an ambulance ride and
And so
felt-
now it's jury
felt
trial
fine.
date.
And then the next day he woke up in severe pain.
So
So I
it's jury
told him,
trial date.
I
And
told
so,
him to go.
so now
and
he
get
wants
it.
to go.
He needs to go. If he has a head injury or a back injury, that needs to be evaluated immediately.
Well, I mean, he didn't evaluate it immediately that night, so.
Well, he felt fine until he woke up this morning. And I
Mhm.
understand that because I've been in a car accident. I've had multiple concussions, so I think he needs to get it figured out.
He needs to hear by Thursday. If he's not here by Thursday with the doctor's note, then a warrant's gonna be issued.
Okay, I'll let him know. Thank you, Judge.
Norma Ali is coming back on Thursday. Okay,
Obligation with the Veterans Association.
okay. Okay,
All the proceeds are benefiting.
Okay. All right. Oh, that's awesome. I'm all for community service work and helping people, so enjoy.
It was in reinforced that OCS
Mhm.
as officer, you have to like really go out there, and make yourself visible to your.
Okay,
especially
awesome.
for veterans, 'cause they have more time.
Okay, sure.
Should I judge my head 5 minutes?
Yes.
You do.
Who's here on Dominique Nicholson? Yes. Where's your client? All right, come down. All right, so where are we on trial with this case? Are we ready for trial?
Well,
Other than his not being dressed for trial?
yeah, I'm ready-ish. I'm
Okay.
ready. Maybe not today ready,
Okay,
but yeah, whenever the case is called, I don't, obviously didn't have him dressed, but I thought I was gonna be in trial in another court. And that case is reset till Monday,
all right,
the Capitol.
all right, Ms. Ferguson, recall this for Thursday. All right, and have him dressed, please.
Okay,
All right, thank
thank
you.
you.
Good
Thank
seeing you.
Thank you, Judge. Just it, well, the court order.
Yes, they're gonna have him dressed.
Okay, because he doesn't need it, he has his clothes already.
Okay, yeah, they'll dress him.
You do.
You're welcome. All right, who do we have left over there?
For my client, Mara Sanchez.
All right. And can I see the file on Eduardo Reyes, please? Norma, have Eduardo Reyes come back on the 7th. And that's a phantom date. He's awaiting transfer to the hospital.
Okay. And then also on Mr. But he's stepping down in a meeting.
All
But he
right,
said he would be here by 2:30.
all right, we'll take him up at a break. And Norma, make sure that the date for Eduardo Reyes is a phantom date, please.
Thank you, Judge.
Mhm.
Judge, can I test out the
Yes.
PowerPoint?
Files, right.
Because there's not.
All right, what is happening with Daniel J. Guerrero? Okay, thank you. Yes. Mhm. All right, and you say Curtis Wilson is going to be a plea? Okay. So the only ones we have remaining then is Sanchez, Omero, and we have Daniel Guerrero and Curtis Wilson, is that correct? And Alejandro, yes, I have that. All right, and what is happening with your client?
Judge, on Mr. Sanchez, we're asking the board to give us a reset so we can continue some discovery. There is a lot. There's probably about 7 or 8 videos and just tons of discovery on this case. I need to look at them because I think some of them are surveillance, and I've got to kind of compare what the police report's saying to kind of what's going on.
Okay, is your client in custody?
He is in
Is
custody.
he out here?
Yes, Mr. Sanchez.
Mr. Sanchez, come down, please. Norma, recall Mr. Sanchez for December 16th for discovery. Is that good for you or no?
Judge, I'm gonna be out. I've got to have surgery.
Ah.
December 5th, we'll be out for about a month and a half.
Ooh.
No.
All right, your attorney's going to be out for a month and a half with surgery. When do you want this call back?
Can we get it maybe like December 2nd or 3rd?
Sure,
See,
we can do December 2nd, 3rd, or 5th.
This is surgery, so that one's out, but otherwise, let's do
You want to do it the 2nd?
the 2nd. It's a Monday. If
Yes.
that works for you.
Yes. All right, Ms. Ferguson. Recall Mr. Sanchez for discovery on December 2nd. All right, do you have any questions? All right, thank you.
Thank you, Your Honor. Appreciate you.
You're welcome.
Thank you. Appreciate it.
How much back in their file?
Okay,
It's a product.
Yeah, there's session.
yes, we're going to do jury selection. You're welcome. Oh, I think I may have given you my paper that I've written on, the docket. Did I accidentally give that to you? All right, thank you. Probably the last one. Wait 1 second. No, I have it. Thanks.
We were in the side room.
Hmm?
We were in the side
Okay,
room when she
sure.
called us.
All right, so what is happening with your guy? He's set for jury trial.
Yeah, moving for Brain, there's basically an impasse. They're trying to see what the complainant may or may not be agreeable to, so
Oh,
I've conferred briefly with them, but that's kind of where we're at.
okay, we're gonna see where we are because something's going to trial.
Okay, no, I
Okay.
understand.
All right, thank
I
you.
was just, okay, I didn't know.
Yeah.
I didn't know if it,
Yeah.
nothing had changed. I was just waiting.
Okay, all right, no problem.
Sorry, Judge.
Oh, no, no problem. Excuse me, can you check and see how much longer they have? All right, thank you. They said it appears that all of us are just playing spoilers now. We're just trying to ruin other people's dreams as we play.
Oh, yeah, that's about it.
So we're asking for help, unless you is asking for help from all the teams.
Hey, if I, the end of the season, if I get that win, I'll be
It's
over. I don't care.
time.
After that point, it doesn't matter. It's like, I'll take 2 losses up to that, you know, I was like, I'll take it, so.
Well, Cornelius, I thought they were gonna win.
But they're playing this weekend
Yes.
against Texas, right?
Mhm.
So, I mean, but any given Saturday with the Florida, they have the athletes, so it's just if they show up.
You never know. You never know. So I'm just like, ugh. So we'll see what happens.
I'm not too excited.
Yeah.
It's sort of, it's like, the season's over already. It's just like, now we're just playing for pride.
Yeah. Well, no, we're just playing to ruin others' dreams. And so
Oh,
people can say, you know what? You didn't even beat this person, but now you're coming to beat us. Yeah.
That's exactly what happened to us. I mean, South Carolina, that's where they were. They were like, oh, this is ruining somebody's season.
Let me just tell you, the team that I never like to see us play is Arkansas.
Oh,
We're always,
it's like they're crazy.
yeah.
I mean, and see, we played them in Dallas every year right now at the Jerry World, whatever.
Mhm.
And it's like, they could be not ranked or anything. We'd be ranked, and it's like, just throws it up in the air, and you just like, they're like a toss of a coin.
Oh, yeah. And then all of a sudden it's like, who is this team?
Yeah, like, it's like, if we didn't know any of these people,
Yeah.
now they just showed up.
It has showed up. And it's just,
And then the following season, they'll lose against Vandy or something like, you know, Kentucky.
or
something.
either they'll lose against Jackson High School.
Yeah,
And you're like,
yeah.
what?
That
Or the
happens-
middle school.
happens to us quite often.
Oh, yeah.
Oh,
So it's gonna be interesting.
it'll be interesting, as long as Ohio State doesn't.
Don't say that to Daryl.
I know.
But you know what? The good thing about the way the rankings are right now, anything can happen.
It's exciting. I mean, it's not like Alabama and all those people are still up there. Now it's like Alabama's reorganized. So I mean, I'm like,
It's
nice to see some other schools up there.
you know, it's the Saturday of separation.
Yeah.
And I'm like, I can't even believe SMU.
We're only like
SMU.
13 or something.
Yes.
That's the height. I read an article, like the little thing, it said the highest they've been ranked since they received a death penalty,
Penalty.
which everybody gets that now.
Oh, yeah.
Everybody gets paid.
Yeah,
And-
everybody gets paid. They're like, come on. But yeah, so it's gonna be interesting. Let me see what we're doing here. I think Georgia's, they're gonna end up winning.
Well, who does LSU play this coming weekend?
Alabama.
That's right. You told me.
And then, okay, Indiana, number 8. Should Indiana be, well,
That's,
no, I'm
they
not
think
gonna
it's
say anything.
basketball. That's what they're thinking. There's no way Indiana's number 8. They're number 8.
Number 8.
No.
And don't get me started on Notre Dame. They can lose tomorrow. And you know what they'll do since they're number 10, they'll put them at 11.
They probably they lose, but they probably go up.
Yeah. I'm like, and Boise State.
Boise State, everyone. I mean, I liked when they played Oklahoma that one year. They did every trick for it in one game. They did the swinging gate, they did the Statue of Liberty, and the tossing kid, whatever. I loved it. I was like, that was awesome.
Oh, yeah.
Like, that was
Everything. So it's gonna be interesting. And Army, 18.
Can't believe that either.
I mean, it's
It
just
was
a
like the
year.
Air Force a few years back got really well.
Oh,
I mean,
yeah.
they were doing well.
You remember when Hawaii did really well, and then they had to play Georgia, and Georgia was very upset. And I think the score, I don't know.
Yeah.
I was like,
Well, Hawaii, the whole essence of playing them is that you get to go to Hawaii.
yeah.
I mean, I was like, that must be cost an arm and a leg for Hawaii to play, because they have to fly people out,
Oh, gosh,
the whole
yes.
team. Oh. Because they had that one quarterback, I forgot the quarterback name.
Oh, yes. You know what? I think, I could be wrong. I think he may have passed. I'm not sure. Let me see.
'Cause
Yeah, I think he
was like-
passed.
The Rainbow Warriors, I remember that, they were like huge. And they had like the most prolific passing that year, like for 1 or 2 years when he was there.
Mhm. Yeah, Colt Brennan.
Mhm.
Yeah, I think he passed.
Really?
Yeah, he passed.
I remember that though. They were like compared to like the Texas Tech, because Texas Tech and Houston had the air raid.
Mhm.
It was sort of back then, so that was pretty.
Yeah. But I honestly, I will tell you, people say what they will about Hawaii, but I enjoyed their story because they were winning.
Oh,
And
yeah.
it's, yeah.
Yeah, especially with like, they don't have a lot of,
Yeah.
I mean, you could live in Hawaii as you play for, but they never had a team. And then
No,
like
and
all of a
then they
sudden
were so, when they were on the field and you saw them standing up against the players from Georgia,
Uh,
they were so tiny. And I
Well,
was like, oh,
I remember the first time we played, I want to say Nebraska here in the Alamo Dome.
Mhm.
Their offensive line, I swear they all had to be about 6'8", 350. I mean, they looked humongous compared to like our defensive players. I mean, because usually, you know, they're offensive linemen are usually bigger,
Mhm.
you know, but my God, these guys all had to be like 6'7" and above.
it was like the people from Space Jam. You
Yeah.
know, the movie Space Jam. You're playing against the people from Space Jam.
That's
You're like, "Oh."
exactly, because I'm never thinking about these people are freaking huge. It's
Yeah.
like the cornhuskers and stuff. Oh,
Oh my gosh, Danielle is here.
yeah, Daniel, I don't know what Daniel's doing.
I'm trying to fix that.
Ah, okay.
Let's see if I can do this.
I cannot because I don't have.
Judge.
Huh?
It looks like they're wrapping up. The sheriff or the bailiff is escorting the families out. It looks like there was like one of the families was kind of upset, so they were escorting people out.
Okay.
But it's wrapping up.
Okay.
continuously throughout that time. It's approximately 2:40 right now. So I've been in court continuously, haven't had a break. I haven't had a break to go eat lunch. We just finished a intensive and extensive sentencing hearing on the sexual assault in the 226 District Court with multiple witnesses. The jury has been out in the hall, off and on for hours. They were all lined up, have been waiting on something to happen, see me come into the courtroom. My fear is that they'll blame me. My other fear is that because of the scheduling for today, that I won't be able to provide effective assistance to Mr. Alejandro. And so that's why I'm asking for this brief recess, to be able to pick a jury, in the morning.
All right, what the court will note for the record that the jury was called up at 11:30. The court excused the jury for lunch and asked that the jury return at 1:30. The entire jury panel was not in the hallway until 1:45. The motion to continue this for another date is denied.
And how long will we have for order?
30 minutes each side.
Because it's a sexual assault case in nature and decency case, I think previously I normally asked for 45 minutes.
All right, 30 minutes each side.
Your Honor, as part of your admonishments, can you please discuss the one witness rule?
Yes.
And I just want to make sure that we have a few more minutes after you finish your admonishments to bring in IT and work on the demo.
Yes. All right, let's bring the jurors. All right. And my understanding from both parties is that he is going to the jury if he were found guilty. Is that correct?
Yes, Your Honor.
And is your client eligible for probation?
According to the indictment, yes.
All right. And my understanding, the charge is indecency with the child contact. Is that correct?
Correct.
All right.
Oh, don't need it.
You're not.
What'd you say? What'd you say about Millhouse? Normally works. I don't know. I think it's a South Page.
Ready, Judge?
Yes.
All rise to adjourn.
Yes. First row. Have a seat, ma'am. Okay, what number is that?
7.
Okay.
She's in the rest.
Number 8 is on the second row. Yes.
Oh, here.
Number 15. Twenty-two.
Yes. All right, everyone, please be seated. All right, so everyone, I appreciate your patience for waiting for us to begin. There were other matters that I needed to take up during the time that you were outside. So know that you were just not standing out there just because I was saying, let's see how long they can stand out there before they knock. All right, so this is what's going to happen now. And I'm asking you to continue to have patience. What's going to happen is I'm going to have them from downstairs. They need to put you in a different order than what you're in now. So I'm going to ask you to get your exercise in, to just step outside in the hallway. You're going to be placed in a different order than what you're currently in. All right. So everyone, please rise for the jurors.
Keep your numbers behind, please. Keep your numbers. Walk up, walk out.
But most importantly, you're not excused from today. You're just going to wait outside for us, okay?
I know.
Together. All right, and you can put it back up now. Yes.
Yeah.
Okay, can you let them know? I'll, if possible, if I can call it after I finish with jury selection. Okay, all right, thank you.
I'll be in contact with them, let them know.
You're welcome. All right, and whenever they're ready, Deputy.
Figure it out.
Is he lining them up? Oh.
He was excited to do the shuffle, so, oh, okay, you're gonna go do it then.
Okay,
So he is there supervising.
all right, awesome.
There's a lot of people.
Mm-hmm. Okay.
Like that, Marco.
Like what? Like, I'm just sitting around.
And to be clear, Judge, that's a non-registered.
Yes.
That's good.
I'll be back there in just a few minutes.
All right.
Oh, yeah.
Yeah. Thirty-seven has nothing shown on this.
I didn't know, they said that Greg Popovich is gonna be out indefinitely with a health issue. Yeah,
Met the, well, it's not my first time meeting him, but the Spurs, the Coyote was at the suicide awareness walk.
oh,
Yeah. I'll show you our picture.
okay.
I walked up to him and I said, you don't know, but you're my boyfriend. He was like, yeah.
Why you watching? No. I'm a little confused on this, Judge, so was this reduced to a misdemeanor?
Yes, it was.
When did you see that?
Sorry, I thought I did, sorry.
That's totally ridiculous.
Or the kind of videos where everybody with the cats like gets their phone and it's it's on duct tape. And they go crazy.
Ready, Judge?
Yes.
Okay. Number one. First row, always to number one. Everybody got any numbers? Number 8, second row.
I'm sorry.
15 on the bench. Okay. Next row. Okay.
All right, everyone, please be seated. All right, everyone, welcome. You are in the 187th District Court. You're on the 4th floor. I am Judge Stephanie Boyd. So what floor are we on? All right. What's the court number? Who's the judge? Okay, you all are the first people who have gotten all of those questions correct. And I know you all probably wonder why I asked that, right? And I see some of you are turning the cards over and you're just like, it's right here. The reason I ask all jurors that question, and the reason why I ask that question and have you all repeat it back to me is because when we take breaks, you're not allowed to stay in the room. You have to go outside whenever we take breaks. And believe it or not, some people will end up getting lost and we have to go find them because we can only proceed if you all are here. So this case that you're here for today is the state of Texas versus Raymond Alejandro. If I could have the state, if you could introduce yourself, please.
Ashley Jones.
Hi, everyone. My name is Raymond Saldana.
All right, defense, if you can introduce yourself.
Good afternoon, Matthew Allen.
I'm Jonathan Chavez.
I'm Raymond Alejandro.
All right. In your possession, you have cards. Whenever you are responding to a question, or if you have a question, please raise your card and wait, and the parties will refer to you by number. What I need everyone to do is to speak one at a time and make sure that you speak loudly, because the court reporter to my left, she has to take down everything that everyone is saying. And if you can imagine, everyone speaks at a different tone and with different speeds, and she has to take that all down. So let's practice. I need everyone to hold up your cards for me, please. And when I tell you to lower your card, I want you to lower your card. So jurors 1 through 14, please lower your cards. Jurors 15 through 21, please lower your cards. All right. If you are a person and your number is still up, that means whenever you are speaking, I'm going to need you to stand if you can, so that the court reporter can hear, because the acoustics are bad the further you get back to the end of the courtroom. Is everyone able to do that?
Yeah.
All right, you can lower your cards. If you successfully do that, you will be the first jurors who have ever been able to do that. Everybody tells me they will do it, and then people forget. All right, so the parties introduce themselves to you. Is there anyone here who knows any of those persons who stood up and introduced themselves to you? If you do, please raise your card. All right. So the charge in this case is indecency with a child by contact. I know sometimes when people are called up for jury duty, they probably want to be next door, which is the civil court. That's the courthouse with the green rooftop. But in order for us to have jury trials, what do you think the number one thing is that we need? Jurors, right? So when the state and the defense talk to you, each of them, of course, will get a chance to speak with you. But when they talk to you, they're going to be speaking to you about hypotheticals. Neither the state nor the defense can talk to you about what they think this case is about as far as what they think the facts are. So whenever they're speaking to you, it's a hypothetical. It's not about this specific case, because they're not allowed to talk to you about this specific case. Does everyone understand?
Yes.
Now, I want to talk to you about an indictment. What is that? Again, we're going to practice raising our cards. How many people here have had a traffic ticket? Don't be shy. Raise your card. All right. Now, this is the one thing that does continue. We continue to have many people who are serving as jurors who are bad drivers. So every jury that I've ever had, cards go up. I've had a traffic ticket as well before. So let me explain to you what an indictment is. An indictment is just a piece of paper to let somebody know what they're being accused of and where they need to be to answer for a trial. Does everyone understand?
Yes.
It's not evidence of guilt. It's not evidence of anything, and you cannot hold it against a person just because there's an indictment. Does everyone understand?
Yes.
So for example, let's say you get a traffic ticket and your traffic ticket is you ran a stop sign. When the officer pulls you over, when I was pulled over for my offense, it was back in the time where they had the paper. They didn't have electronics, so you get a piece of paper, right? So they wrote on the piece of paper what they saying you did, and they give it to you. And on that piece of paper, it will tell you, this is what I'm saying you did, and this is where you need to go to answer for that. If you want a trial, you can have a trial. By me accepting that piece of paper from that officer, that doesn't mean that I'm admitting that I'm guilty to it or not. It's just so I'll know what I'm being charged with. It would be odd if you were to get a traffic ticket and they say you ran a stop sign, and when you get there, they say, surprise, it's for not yielding. So that's all indictments are, but you're not to hold it against Mr. Alejandro. Is there anyone here who's going to hold it against Mr. Alejandro because he's here under indictment? All right, now the next thing I want to talk to you about is certain rights people have. Yes, number 50.
Can I come speak with you real quick, please?
Just one moment. All right. All right, the next thing I want to talk to you about is the right to remain silent. How many people have seen The Practice, Paper Chase, Mannix, Barnaby Jones, any of these legal shows? All right. So they have the Beretta, they have the right to remain silent as a part of things. What does that mean? That means that you don't have to testify if you don't want to testify. I've been a defense attorney, I've been a prosecutor. As a defense attorney, sometimes I would tell my clients, look, you don't need to testify. The state didn't prove their case. What's the point? And then sometimes I would have clients who were so terrified of testifying, not because they've done anything wrong, but because it's hard to sit in this chair and everybody's looking at you. So there are many reasons why somebody may decide not to testify. I will tell you, people who have never had to testify before, usually they will say, well, if it were me, I would make sure I testified. And I always tell people, yeah, but it's not you. If it were you, maybe you would be thinking something differently. But the main thing about the right to remain silent is that a person doesn't have to testify if they don't want to. Does everyone understand?
Yes.
And our constitutional rights say that if someone decides not to testify, you can't hold it against them. You can't consider it. You can't be like Mrs. Kravitz from Bewitched saying, I wonder what they would have said. You just can't consider it at all. Does everyone understand?
Yes.
If Mr. Alejandro decides not to testify, is there anyone here who's going to hold it against him? All right. Now, the next thing I want to talk to you about is presumed innocent, right? Everybody who is charged with a crime is presumed to be innocent unless and until the state proves its case beyond a reasonable doubt. Now, beyond a reasonable doubt, what is that? What does it mean? When I first graduated from law school, everyone had to know the definition of proof beyond a reasonable doubt. I learned the definition. You were so terrified because you had to know it backwards and forward. I knew it backwards and forwards. I knew where to put the comma. I knew where to put the exclamation point. I knew where to pause for a dramatic effect. I had my first jury trial. I was so proud of myself because I said it without stumbling. After my first jury trial, guess what happened? There's no longer a definition for proof beyond a reasonable doubt. I still remember the definition, but no such definition exists legally. So neither the state nor the defense will be able to tell you what proof beyond a reasonable doubt means because there is no definition for it. Does everyone understand?
Yes.
So when I was a prosecutor and defense attorney, I would explain it to people by telling them what it was not. Next door, that's the civil side. On the civil side, you have civil cases that involve money, where if you are found liable, you're probably going to have to pay a fine. or you have family law cases over there that deal with custody issues. So over there, they have a burden called preponderance of the evidence. More likely than not, something happened, right? If you are ever on the criminal side and you are deliberating and you're analyzing the case and the facts that have been presented to you, and you say, I believe this happened more likely than not, you know you are not at the correct burden of proof, that is not the burden of proof for criminal cases. Does everyone understand?
Yes.
They also have another burden over there, and that's their highest burden. It's clear and convincing evidence. Clear and convincing evidence is the evidence that's needed to terminate someone's parental rights. They're saying you're a danger to a child. We can't trust you to be this child's parents. That burden is the highest burden they have. But there's a burden that's even higher than that. And that burden is proof beyond a reasonable doubt. Does everyone understand?
Yes.
Next, I want to talk to you about fairness. What is fairness? Because everyone will ask you, can you be fair in a case? Everybody who walked through that door, you were just not born yesterday and you didn't sleep all last night. And I say that because everyone comes with experiences and thoughts and feelings. Nobody's asking you to forget your experiences or any of that nature. The only thing about fairness in any of these cases is whether or not, no matter what has happened to you in your past, if you were a juror on this case, can you listen to the evidence and make a decision, if you can, on whether somebody is guilty or not guilty based upon the evidence that you hear? Does everyone understand?
Yes.
So in cases like these, sometimes people will say, well, I had a bad experience that happened to me. It's okay to acknowledge that. But the question is whether or not, if you had a bad experience happen to you, are you going to hold it against the person who is on trial? Does everyone understand?
Yes.
Yes.
So is there anyone here who has an experience where they're saying, you know what, I'm not going to be fair. I'm going to hold it against my experience against Mr. Alejandro. Is there anyone who feels that way? Now, the next thing I want to talk to you about is phases in a trial. There are 2 phases to a trial in Texas. People always say the first phase is the innocence phase, but it's really not. The first phase is simply, did the state prove their case or did they not prove their case? That's it. If the state failed to prove their case, then that means your verdict should be what? Okay, we're going to try that again. If the state fails to prove its case, what should your verdict be? Right. If they prove their case, then what should your verdict be? All right. So if the verdict is not guilty, there is no phase 2. If the verdict is guilty, there is a phase 2, and that's called the punishment phase. Now, in this case, indecency with a child by contact, there's a wide range of punishment. The range of punishment is potentially probation and anywhere from 2 to 20 years in prison. So what does that mean? If someone want to be sent to prison, they can be sent to prison anywhere from 2, 3, 4, 5, all the way up to 20 years. Does everyone understand?
Yes.
Or they can be given probation. You don't know any of the facts of this case. Nobody's going to be allowed to give you what they think the facts of the case are. So what I need to know from everybody is, do you acknowledge that it's possible that someone can get probation, or either they can get anywhere from 2 to 20 years in prison? Does everybody understand that as the range of punishment?
Yes.
Yes.
Now, if you were to find somebody guilty, what you would have to do, if you can, is look at the facts, whatever is presented to you, and make a decision on what you would think would be the appropriate punishment. Does everyone understand?
Yes.
Is there anyone who cannot consider the full range of punishment? All right, that's number 8. All right, the next thing I want to talk to you is about what's called the one witness rule. there are many times you will have an offense where there is one witness. Let me give you a hypothetical, and this is the hypothetical that people usually give. Let's say you go to a game, you leave late, everybody has left, and you're the last one who's leaving because, oh my gosh, I forgot my phone. Let me go back to the stadium and see if I left my phone. You're able to make it in, you're like, great, I found my phone. So get your phone, you're walking to the parking lot, and you're like, you know what, I'm gonna take a shortcut. So you take a shortcut, and you take a shortcut through an alley. And it's only you walking through that alley. You think you may hear footsteps behind you, but you're like, oh, it's probably my imagination. You continue to walk through that alley, and it wasn't your imagination. And somebody pushes you against the wall, they pull a gun on you, they grab your phone and take off. Is everybody with my fact scenario? Yes. So only two people in the alley, the person whose cell phone was taken and the person who took the cell phone. How many people think just because there are only two people in the alley that we should say, too bad, so sad, there are only two people there, so we're not going to bring any charges? Is there anyone who feels that way? All right, so let's say it comes time to a jury trial. And the person whose cell phone was taken, they're like, yes, I will be there to testify. They sit here, they raise their right hand, they swear to tell the truth. They're giving their testimony. They say how they went back to the stadium to get their phone. They tell you everything that I just told you. And they say, let me tell you, I see the person in the courtroom who did this to me. And let's say they say it's John Doe. That's John Doe right there. That's the person who did it. That's the person who took my phone. And you believe that person. They've identified the person they have. They said, that's the person who did it. I know them because this is how they looked and they had this scar on their face. They give you all of this information. And that's the only evidence you have. That person's statement. Does everybody understand?
Yes.
Now, that person who's testifying, it could be Mother Teresa, it could be the Pope, it could be whomever. But you believe them. You believe they're telling the truth. That's what the one witness rule is. Whether or not, when someone is called to testify, if you believe that person and that person proves every element that the state has to prove, for example, in the hypothetical that I've given you, that witness says, this is the day it happened. It happened in Bexar County. My phone was taken. That's the person who did it. All right. They've hit all of the elements and you believe that person. Everybody still following my hypothetical?
Yes.
Is there anyone here who would not be able to find the person that's being accused guilty in that situation? Now, when you think about it, sometimes I'll give a hypothetical and people will say, well, but maybe they didn't have good eyesight. Then what that means is you have a question about their testimony and whether it's truthful or not. The hypothetical that I'm giving you, there's no question in your mind that they are telling the truth, that they've identified the person who did it. Does everyone understand?
Yes.
So there are many cases where there's only the person who's accusing the person and the person who is accused. Does everyone understand?
Yes.
So that's where credibility comes in, and you judge whether or not the one witness, if there is only one witness, you judge whether or not you believe they're telling the truth or not. Is there anyone here who cannot do that? All right. The next thing I want to talk to you about is the English language. I love languages. I was supposed to be living in Paris, but I'm not. That's why I took French. My friend told me, Stephanie, you should take Spanish with me. And I'm like, we're in Louisiana. What are we going to be doing with Spanish? I'm going to Paris. Lo and behold, I ended up in law school here, and I regret that I didn't take Spanish. So is there anyone here? English is not your first language. Please raise your card. We have 2, 13, 22, 25, 30, 37, 48, 57, 73 and 75. All right, number 2, what is your first language?
Spanish.
All right, have you been able to understand everything?
Yeah, pretty much, yeah.
All right, what does pretty much mean?
I would say 98%.
All right, and when you say 98,
One of the problems I have is that I have a hearing problem.
all right, thank you for letting me know. Number 13. Yes, what is your first language? And where? TAM. And where is that from?
That's from State Road on the lobby.
India. We're gonna make it easy for the court reporter. We're just gonna say India. All right, thank you. How do you say hurry up in your language? I just put her on the spot. All right. I will tell you, the classmates I had, some of them spoke about 8 languages. So I can pretty much say hurry up in every language. That's what they've taught me. All right. Have you been able to understand everything?
Yes, ma'am.
All right. Number 22. All right. See, I thought you guys would stand if you're not on that wrong. But we're going to pretend like it didn't happen. All right. What's your first language?
English.
Oh,
Spanish. Well, as far as English and Spanish, or the first language?
the first language.
English.
Oh,
I must have, I guess I answered wrong, sorry.
no problem. Have you been able to understand everything?
Yes, ma'am.
All right. Thank you. All right. 25.
Spanish,
Have you been able to understand everything?
like 7%.
70%? All right. You know, in school, 70% now is still passing, but okay. All right, number 30.
Spanish,
Have you been able to understand everything?
probably 50%.
Okay, see, now he knows that 70% is taking us to 50%. All right, thank you.
All that I don't know how to read or write English and.
All right, well, I will tell you this, legally, to be on a jury, whether you read or write English is not the issue, but you must be able to read and write. But you're at 50%. All right, thank you. Number 30. Number 30, who's 30? Oh, you're 30, okay. 37. Hello,
Hi.
what's your first language?
Hindi,
Ah,
I didn't hear it.
Hindi. Have you been able to understand everything? All right, thank you. 48.
Spanish.
Have you been able to understand everything? All right, 90%. See, she still wants to pass, but she's like, all right, 57.
Spanish.
Have you been able to understand everything?
Yes.
Thank you. 73. Have you been able to understand everything? Thank you. 75.
Farsi.
Ah. Have you been able to understand everything? All right, thank you. Yalla, yalla. Thank you. Hey, that's Arabic, I know. Yeah. One of my friends is Arabic. That's what she taught me, but she speaks that as well as Farsi. All right. So, is there anyone here who has any type of travel arrangements? I expect this trial to be done by no later probably than Monday. So is there anyone who has any travel arrangements outside of that? 21, 35, 51. All right, so this is what we're gonna do. Everybody, think about what I've just said. You all have the question in your mind? So anyone who has travel arrangements, now's the time to raise your card. All right, so 21, any travel arrangements or time constraints? So we have 21. All right. Everybody raise your cards down. Once I pass your number, I'm not going to come back. Anybody over here? Any time constraints? All right. So we have 15, 17, 19, 21, and you can lower your card once I call your number, 27, 28, 33, 37, 39, 42, 45, 46, 51, 54, 55, 61, and 71. 15, what is your time constraint?
Friday afternoon,
What are you doing Friday afternoon?
me and my daughter going hunting.
Hunting, all right. Does your daughter want you with her? All right, number 17.
I'm a pig baker and I actually have orders going out tomorrow and a wedding on Saturday that I have to deliver.
All right, and if the cake isn't delivered for the wedding, is that gonna ruin the wedding at all? All right. Number 19.
That's me, sorry, I think I misunderstood. It's not till the 26th.
Okay,
I
awesome.
apologize.
21.
Friday morning,
All right, what is happening Friday morning?
flying to Vegas.
What are you doing in Vegas? Should other people not know?
Gamble family.
All right. I thought you were gonna say, hey, I'm gonna be in Vegas, but let's just pretend I'm here for trial. Okay. All right. 27.
I also misunderstood the question.
All right, thank you. 28.
I know you said through Monday. I know you said through Monday. I know that's a holiday, but I'll be out all next week starting Tuesday.
Oh, when I say through Monday, of course, people will have the Monday off, but that's when I'm expecting it, maybe that week. But
Okay.
what is happening with you?
Oh, I'm going to Palm Springs
Palm Springs? What are you doing in Palm Springs?
vacation.
All right, thank you. 33.
I don't have a driver's license, so I require to be driven around by my parent, which she works a lot, and her schedule usually varies
All right, via?
via car.
No, via bus.
Bus,
Yes.
I've tried, I don't think many buses get to our area.
All right, well, we're gonna have to check and see. All right, thank you. 37.
My brother-in-law is out of town and my sister doesn't drive, so I pick my niece from her school every day.
All right, and what time is that?
That is, I drop her in the morning and then I pick her up in the evening
All right, what time do you drop her off?
around 8:30. And then I pick her up around 2:30. I go to school at 2:30 and then pick her up around 3:15.
All right, and she's okay today, right? She's okay today?
Yeah, today I told my neighbor to do it.
All right, thank you. 39.
Got doctor's appointments, a dental appointment tomorrow, and then a doctor's appointment on Monday. Dental appointments at 1:30 for a bridge.
Oh.
A crown.
All right, thank you. 42.
I have a doctor's appointment at 9 o'clock on Friday, and then I meet my mother at her appointment because she cannot get out of the car and to the doctor by herself.
All right, okay, thank you. 45.
Appointments with the VA tomorrow and on Friday.
All right, what time on Friday?
Friday hasn't been set, but tomorrow at 1 p.m.
All right, thank you. All right, 46.
Yes, I have a day job and a night job, and my daughter, I also just bought a house, so I have installations scheduled this week as well.
All right, thank you. 51.
My wife is having surgery on Thursday and I'll be her primary caregiver. And then next week, I'm flying to California for a medical conference as part of the transition to a new job in Washington, DC the following week.
All right, so are you gonna do a great job with your wife? Sometimes with guys, it's like, it's more problematic. Are you gonna be able to do it nice for her?
I will do an absolutely wonderful job with my wife.
All right, awesome. Number 54.
From Wednesday, November 13th to Friday, November 15th, I'm gonna be in Dallas for work.
All right, doing what?
It's a workshop, a public speaking workshop.
All right. Number 55.
I fly to Houston on Sunday. And then on Monday, I fly to Brownsville for medical appointments. My business is in Brownsville, but I have medical appointments on Monday.
All right, thank you. 61.
Leaving Thursday morning to attend Texas Lyceum Conference.
I'm sorry, to attend what?
Texas Lyceum Conference at South Padre.
Wait a minute. South Padre, what's really happening? All right, thank you. Number 71? Yes.
Oh, yes, I have to take my kids to school in the morning and then pick them up in the afternoon because my son goes to college.
All right, what time?
I drop him off at like 7 o'clock in the morning.
Mhm.
And then I wait till he gets off at 4:30 because we only have two cars and my wife.
All right,
picks the
so
other
your
kids.
drop off,
Yes.
your morning drop off is 7 a.m. When is your pickup?
My pickup is at 4:30, so after work, I go over there and pick him up after I get off of work at 4:30.
All right, thank you. 64?
I have a doctor's appointment that I made 6 months ago
Okay.
on Thursday.
All right, what time?
I think it's 9 o'clock.
Okay, all right, thank you. And I saw somebody over here come lately, number 10.
Understood. I don't know if this pertains for tomorrow. I have a injection set up for 9:30 with the eye doctor, and then my diabetes at 4 o'clock.
All right, just so everybody know, the persons who are selected for this jury, I'm not gonna have you come in tomorrow so that if anybody needs to vote or whatever, they can go do that. So we're not gonna come back tomorrow. We'll come back on Thursday. All right, number 8.
Your Honor, I don't know if this is pertaining to your question, but I just started a new job. And if I don't go to work, I don't get paid, and I'm the breadwinner in the family.
All right, thank you.
Wanted to make sure we're talking about on Thursday or Wednesday.
I'm sorry, Wednesday. Thank you. I keep saying Thursday in my mind because I think today is Tuesday. All right, number 22.
Yes, ma'am. I'm sorry, I apologize. I didn't realize the question, but I didn't realize Monday was a holiday, Veterans Day holiday.
Oh, that's the 11th. We're not going to be here on that day. Yes. All right, thank you. 36.
Your Honor, my wife is gonna be out of town. My daughter, I drop off at 8 and have to pick up at 4 on Wednesday and Thursday.
All right, thank you. 53.
Your Honor, I have a critical function job at my credit union, and if I'm not there, people might not get paid, so.
All right, but do they really need to be paid? When is this?
Beginning tomorrow. I'm one of only 2 in the credit union right now that have authorization to process a particular function, so.
All right, thank you.
What's your number again?
53. Number 2.
I have a dentist appointment on Friday, this Friday.
All right, thank you. All right, 20.
I have a dentist appointment tomorrow, but I think I'm gonna cancel it because it's 2:30 in the afternoon.
No, we're
Oh,
tomorrow.
tomorrow's nothing.
Yes, tomorrow we're not going to be here. But thank you for letting me know. All right. So I'm going to tell you all 2 stories, and both of these stories are true. My family grew up in a small town called Grand Cane, Louisiana. And my uncle, who's since passed, my grandmother has since passed, but my uncle was super intelligent. So that was back in the day where every teacher knew every student. And when I say every teacher knew every student, it doesn't matter whether you were in their class or not, they knew all of the students. So my uncle would keep getting passed from class to class because the teachers would say, we've taught him all we can teach him, Miss Lane, we're going to move him to the next class. So he would get moved. Now, when his sister and brother came through that same school, they were a little bit upset because the teachers were like, we've seen your brother, we're expecting a lot from you. So my uncle ends up graduating. And when he graduates, the Vietnam War breaks out. He goes to my grandmother, and he's my grandmother's firstborn. And he tells her, because of the times that we live in, I'm not going to be able to improve my lot in life. And they're already drafting all of the boys here. I just want to go ahead and sign up. But in order for him to go, because of his age, she had to sign for him. And I always tell people that these are sacrifices and that jury duty is an inconvenience. It's an inconvenience because you have to stand out in the hallway and wait. There are not a lot of seats. You're downstairs, you're rushing to get here at 8 a.m. And then you find out it's hurry up and wait. There are a lot of one-ways. But when you think about the sacrifice that my grandmother had to make, they only had television that had 3 stations, ABC, CBS, and NBC. And you really couldn't count on NBC because the weather had to be absolutely perfect for you to get that station. And then The way, young people, the way you have news 24/7 and you can watch television anytime you want, 2 a.m., 3 a.m., that's not the way it was back then. It's at a certain point, there's no more television and it just turns off. And then when they got real fancy, they would have the flag waving and they would play the national anthem. And that would be it. Your TV would just have a flag waving. That's it. And then you wait for television to start again the next day. My grandmother, her phone. And young people, I know you don't know what a touch tone is. I know you don't know what a rotary is. But her phone was neither a touch tone or a rotary. You just would pick it up, the operator would answer, and you would tell them what number you wanted dialed. That's why you would have those songs, Beechwood 45789, because you pick up the phone with the operator, they say, who do you want? Oh, I want Beechwood 45789. So my grandmother quickly learned, and my grandmother only had a 6th grade education, but she was super intelligent. She quickly learned that the one thing you did not want during this time frame was to have the military come knocking on your door, because that was very bad news. They didn't have a computer. Computers were not really in existence, so there was no way for her to shoot off an email or to call her son and say, hey, did you arrive in Vietnam okay? You just had a number, which was his ID number for the military, and you would send a letter and you would put Vietnam on there, and hopefully it would get that, and then it would come back to you in a matter of months' time. So that's a sacrifice. So when people come for jury duty, I always tell people, for example, Veterans Day, Memorial Day, 4th of July, everybody wants to wave a flag and say, rah, rah for our troops, rah, rah for our country. But then when your country asks one thing of you, to do jury duty, people come up with excuses why they can't do it. And really, when you think about it, your country only asks 2 things of you: jury duty and to pay your taxes. And with jury duty, your country is not even asking you to come out every 3 months. It's like once in a blue moon. How many people here have served on a jury? Raise your card. Look around, people. See how little number of people have actually served on a jury. So your country doesn't ask that much of you. So this is, of course, a serious business that we're here to today. Both sides want there to be a fair trial. And the only thing that each side is going to be asking for you is for you to listen. And if you can come to a decision to base it upon what you hear, that's all they're asking. And remember what I said about fairness. Both sides are going to have 30 minutes to speak to you. They're trying to get a chance to know you so they can make a decision and see who would probably be the best people to sit on this jury. Does everyone understand?
Yes.
Second story I'm going to tell you is about my friend from law school. She decided to do civil law. I always wanted to do criminal law. She calls me up. She says she has jury duty. And she said, let's do lunch. I'm like, great. We do lunch. I ask her how jury duty is going. She tells me fabulous. Now that I'm a judge, I'm like thinking, how could it have been fabulous? You were not with Stephanie Boyd. What's going on down there? And she said it's fabulous because she knew she wasn't going to be on the jury. I said, how do you know that? She said, it's just like in law school. I'm on the back row, keeping my head down, not answering questions. And I laughed. And she said, what's so funny? I said, we're going to get to have lunch every week. So other than raising your card and saying, please select me for this jury, the other way to get on this panel is to be absolutely quiet. And I tell you that so that you can speak to both sides because they really want to hear from you. All right? Does anyone need a break before I turn it over to the state? All right. And juror number 50, don't worry. We'll talk to you in private, okay? All right, state.
Thank you, Judge. Good afternoon, everyone. So before we get started, I'm just curious, how many of you all have seen the show on Amazon Prime called Jury Duty? Has anybody seen that show? Juror number 56, you're smiling. Tell me why. What's the show about?
It's like
I can't hear.
Stan, please.
it's a reality show where there was one civilian and the rest were actors.
Yeah, so I'm here to tell you, we're not all actors, okay? This is the real show. So if you think that all of us are actors and you're gonna be told at the end of the day that it's a little joke, it's not. It's the real thing, right? Welcome to the jury selection. The judge did talk about that this is a This is an inconvenience, right? And it's important because this week is election day, right? Tomorrow. And no matter which side you're on, whether you're on the conservative or the liberal side, at the end of the day, it reminds me that our three branches of government are really run by the people, right? We elect the Congress in the elections, we elect the president. And in the judicial branch, which is where we are right now, it's the jurors that make the decisions at the end of the day. It's the people. So I really am thankful for you all to show up today. I know that some of you all though may have problems with this kind of case because. Let me take her. Uh-oh. It died. Well, anyways, you can just pushing and see if it works. So there are a few rules that I want to adopt. Jury selection, we're here to pick up 12 jurors, right? 12 fair and impartial jurors. And there's two rules that I want to adopt. Rule number one is. What happened? I could be wrong. It's sometimes it struggles. So rule number one is being honest, right? We're here to be honest and to be respectful. We're not here to change everybody's views. I'm not here to try to adopt certain positions. I'm just here to get to know you, okay? And number three is the way that we're going to do this is by having a discussion. So I'll give you guys an example. Juror number 15. What's the best ice cream flavor out there?
Chocolate.
Chocolate. Raise your number if you agree with number 15 that it's chocolate. There you go. That's exactly what we're going to be doing during jury selection, okay? Oh, look, it works now. That's the purpose. 12 fair, impartial jurors, honest, and open discussion. Okay, so I want to talk about what the law is, right? This is a charge of indecency with a child contact, and these are the elements that we have to prove. Is on a particular day in Bexar County, Texas, the defendant with intentionally knowingly engaging in contact with a child younger than 17 years old. And this is what we have to prove. We can prove by touching the child's genitals or the breast, or by causing the child to touch the defendant's genital or defendant's genitals, with the intent to arouse or gratify the sexual desire of any person. This charge does not mean there's any penetration. This is contact, okay? And it could be over or under the clothing, okay? The main key here is with the intent to arouse or gratify the sexual desire of any person. So touching a child in the genitals is not necessarily a crime. And I'll give you an example. If I have a toddler and I'm changing their diaper, what am I going to do? I'm going to have contact with the genitals because I'm cleaning the area. But if I do it with the intent to arouse or gratify the sexual desire of my person, then that becomes a crime. Does that make sense? Yeah. Okay. The judge did talk about the range of punishments. It is a second-degree felony, 2 to 20 years. Remember, it's a contact in this particular situation. She also talked about the burden of proof. And here's the levels that she talked about, just so you can visualize it. Preponderance of the evidence, that's in the civil case. Clear and convincing, that's when the state the state is trying to terminate the parental rights. And beyond a reasonable doubt is the burden of proof in a criminal case, right? So I can't really tell you what beyond a reasonable doubt is because there's no legal definition, as the judge just said, right? So what I can do is I can tell you what it's not, and that is it's not beyond all doubt, okay? The key word is reasonable. So I'll give you an example. I want you to all imagine that you're going to the movie theater on a Saturday or Sunday early afternoon. You're going with your family, you're going with your friends, and when you go into the movie theater, you enjoy your movie, and as you're walking out into the parking lot, you see this, right? Juror number 16. What happened?
Rain.
Well, juror number 20, you answered, right?
Yeah.
It rained. Do you agree, juror number 16? Okay, juror number 21. Why would you say it rained? What can you look at the picture that leads you to believe that it rained?
The water on the asphalt.
Okay. Juror number 17, what else?
Cloudy.
It's cloudy. Juror number 5, what do you think? Well, so if you're walking into the parking lot, you may see water in the cars, right? As you get closer, you can't tell in the picture. But you're right, it could be something else. And that's where the beyond all doubt comes in, right? Is it possible that the San Antonio Fire Department came in and gave everybody a free car wash? Right? Is it possible? Yes. Is it reasonable? No. I don't have to bring in the chief of the fire department to tell you that it didn't happen, okay? Because it's not reasonable. That's the keyword that I want to talk about it. It's also not about the amount of evidence. It's about the weight of the evidence, okay? And the judge did talk about the one witness rule, right? We could just have one witness, but if that weight is enough to get us to beyond a reasonable doubt, then that is enough, okay? I do have a question, okay? For you all. Which goal should be more important in a criminal justice system with sexual abuse cases involving touching a child victim inappropriately? There's number one, which is, should we rehabilitate? Should the goal be to rehabilitate, and that's prevent the crime by focusing on the offender and try to change him or her? Or number two, to punish, preventing crime through a penalty or confinement. I'm going to be asking you all what you all would pick, okay? And I know this is a situation where some of y'all may not agree on one or the other. Pick the one that is closest to what you believe, okay? Raise your number if you agree with number one, rehabilitate. And keep them up. We're gonna write them down, okay? Juror number 2, juror number 5, juror number 7, you can bring them down after. 16, 17, 19, 20, 23 through 26, 29, 31, 33, 40, 46, 47, 51, and 65. Okay. It's fair to say that the ones that didn't raise your number, would you all agree with number 2?
Yes.
Okay, is there anybody that just would not agree with one or the other? Juror number 36? Okay, remember now, you have to pick one or the other, but if you strongly feel like you just can't pick one or the other, juror number 28, 36, okay. Thank you. So let's talk about evidence. So in a trial, in a criminal trial, what are you gonna have? Evidence, right? So let's talk about what is evidence, but before I tell you what is evidence, let me tell you what it's not. And that is the defendant's criminal history, if there is one, okay? This is not something that I can tell you. There's exceptions that apply, but for the most part, you're not going to hear any of that, okay? In the guilt innocence phase, if it goes to a sentencing, that's a different story, but in the guilt innocence phase, where you have to make a decision whether he is or she is guilty or not guilty, that doesn't come in. Police reports. A lot of people are thinking, well, isn't that important? It is, but it's also hearsay. What's better though, you won't have the police report, but you will have the officer come in and testify. He's going to tell you his personal knowledge, okay? Footage of any prior statements, that's also hearsay, except if it's the defendant that says it, okay? Why? Because again, we want the witness to be here. We don't want the statements from back then. We want them to be here. If there's any inconsistencies, don't worry. Either side is going to clear it up, okay? The forensic interview, I do want to talk about this because it involves a child. In cases like these, children get interviewed by a forensic interviewer. And this is a one-on-one interview where the interviewer asks open-ended questions. They're not suggestive. They're not intended to be intimidating in any way. The interview is recorded. But of course, it's not admissible because you're going to have the child here, right? It's also a tool to help the investigation. So all that stuff is not evidence. But most importantly, if it's not before you in the deliberation room, it's not evidence. Okay? So now let's talk about what is evidence. Raise your number if you've seen these shows in the past. I think everybody's excited about this. Yes. Okay. So these shows are designed to be dramatic. Yes. Exciting. There's the cue the music in the background. There's the lawyer that comes to the witness stand and then starts getting very confrontational. You're not going to see that in real life. Okay. And that is, you're not going to see any DNA. And if you do, there might, but for the most part, you're not going to have that evidence that's going to get you there. Because if there is, chances are that's why it may not even go to trial. It might resolve before we go to trial. It's the trial cases that are the difficult ones that have to that go to the jury. You may have some evidence, such as photos, maybe audio recordings, videos, medical records, but the most important piece of evidence that you're going to have as jurors is testimony. Okay, and we talked about it, right? Again, with the one witness rule, it's the testimony. Testimony is evidence. Now, It involves the child, right? Juror number, let's see, raise your number if you have any kids. Okay, young kids at the moment. Okay, that counts, yeah, actually. Juror number 3. Do kids lie? Yes. Does everybody agree with juror number 3?
Yes.
Do kids lie?
I'm a.
Do adults lie? If adults lie, it makes sense if kids lie. Yeah, but do they lie to get into trouble or get out of trouble? Get out of trouble, right. Do they lie to make things easier and better for themselves or harder and worse? Easier, right? So who here has lied about something when they were a kid? Raise your number if you lied before when you were a kid. Everybody should be raising their hand. At some point, I would imagine somebody has made a fib before, right? Whether if it's to parents, to a teacher. So raise your number. Actually, keep them up there. Keep them up there. Now, I'm gonna ask a question, which if you don't feel comfortable answering, then that's fine. But who from everybody that has their numbers up there, who has lied about being molested by a family member in the past? And that's the point that I want to get at, okay? It's not very common. Yes, kids lie, but when it comes to lies about these serious things, it's very difficult for that to happen. Now, I want everybody to not close their eyes, but I want you to imagine, I'm going to take you back to the time. If you haven't, then this may not work for you, but imagine the time when you first had your first sexual experience with a partner. Okay? Sexual experience more than kissing. Okay? Who can I ask? I'm just kidding. I'm not gonna ask anybody. What came through your mind when you thought about you being the person that's gonna talk about that experience? Anybody? Did you get a wave of discomfort? Yes? Embarrassment. Embarrassment. Who said that? Juror number 3? Yeah. You know why? Because it's embarrassing. It's not something that people like to talk about, especially with other people. So how do you think a child is going to feel, right, when they testify about these things? How do you expect them to behave on the stand? Juror number 2, what do you think?
Intimidated.
Intimidated? Okay. Juror number 4, what do you think?
Real nervous and scared.
Nervous and scared? Juror number 5? Same. 6? Anything else to add? Afraid, which goes back to the scared part. Yeah, because everybody is looking at you, right? It's a difficult subject matter to discuss. And, well, you're talking right in front of the person you're accusing, right? The accused. But do all children react the same way, though, when they testify? No? What are some ways a child would react? What are some different ways a child would react? I mean, you have children that, of course, are able to react emotionally when things like these happen. Others just don't. Is there anybody that feels that, you know what, if a child has been sexually abused, a child needs to react in some way emotionally? Who feels that way? Raise your number if you feel that way. So if a child doesn't react emotionally, does that mean it didn't happen? Who feels that way? Juror number 3? Did you raise your number? I'm sorry. Yes or no?
Well, I mean, it doesn't mean that it didn't happen.
It doesn't mean that it happened. Does everybody agree with juror number 3? Yes? Yeah, because every child is different. And I use this picture because, well, in this case, it depends how you see it, right? You're in a roller coaster. It could be an exciting experience or it could be a traumatic experience because every child is different. What does a sexual abuser look like?
Anybody?
Anybody? Juror number 3? Does anybody know who these people are? Yes, juror number 19? Who do you know?
I guess I don't know their names, but I know the news stories. Yeah, first one was a teacher, and the second one was a coach, third one was a coach.
Okay, 21, what did you mention?
Nesser and the guy from Penn State.
The guy from Penn State. What happened to the guy in Penn State? Does anybody know?
Yeah, he went to
Louder.
prison. Oh, he went to prison
For
for molesting, I don't know how many boys,
boys, young boys.
young boys.
Okay, and this was in, you remember the year?
It was a long, what was it, 20 years, give or take, like 70s through the 90s?
But do you remember the year what he was?
Oh, when he actually, no, it was,
No? Okay. Yeah, I mean, I think the main thing that an abuser needs is two things. Right? It's trust and access. And that makes these people extremely dangerous. Because the people that you least expect who have access and who you trust could be sexual abusers. Where would a victim of sexual abuse most likely be abused? In a crowded area or in a secluded area? Secluded, okay, where there are no what?
Witnesses.
Exactly, and that's the hypothetical that the judge was giving you earlier, right? Who controls when the incident happens, when the offense happens? Well, the abuser, right? They determine the time and the place. It's maybe sometimes it could be an opportunity. I want to talk to you about the outcry. The outcry is the moment that the child discloses the abuse. Do you all think that children report abuse immediately? You're shaking your head no. What's your number? 28?
Yeah.
Tell me why you think it's a no.
Because
Please stand.
sometimes they're ashamed. They don't want to say anything, or they think that something bad's gonna happen to them.
Okay. Is there anybody else that wants to add something more? For your employee?
They feel like they've done something wrong.
They feel like, so guilt in a way, okay? Juror number 3?
They've been threatened.
They've been threatened, okay. Do you think maybe who the actor is may make a big determination as to whether to tell or not? The relationship? Okay. Juror number 13?
They might feel traumatic at that moment and not know how to react because they are sleepless.
Good point. Traumatic, and you're trying to process what happened, right? And you're trying to determine what is this and is this all right? Juror number 29?
They don't want their abuser to know they told on them.
They don't want the abuser to know that they told on them, okay? Because of maybe fear, okay? 26?
They may not know something wrong even happened in the first place.
Alright,
Like foreign to them, it's never happened before.
so you can't recognize what is sexual and what is normal? Okay. 61?
I can't see her, counsel. Could you repeat that, please?
One more time.
They're gonna think that, they're believable.
Okay, they're afraid that they're not gonna be believed. Yeah, so these are the reasons that we have, and I think everybody touched on these, right? Embarrassment, fear, guilt, helpless, worried that no one will believe them. That's the last one that you actually touched on. Let's talk about memory. Let's see. Juror number, let's see, juror number 10, where are you? Juror number 10, what is your earliest memory that you can remember? Four? Do you remember where you were? When it was?
In the summer.
What happened? Okay, and who was there? And who was there?
Family.
Do you know who exactly?
No.
No? Do you know the time of day? Do you know the exact date? No? Okay. So I think it's fair to say that for an early memory, you know some of the details, not all the details, okay? Put a bit on that. Juror number 21. I asked you earlier, when was one of the pictures that I put up there, when was he convicted? And you said you have no idea.
Yeah.
Right? Does that mean it didn't happen?
No.
Why not?
There's proof that he actually went to jail, actually went to court, got convicted.
You remember reading it, right?
Yeah.
Or reading about it or hearing about it.
Hearing.
So the fact that you don't remember the date or the year, does that mean that it didn't happen? No. Who agrees with jury number 21? That the fact that you don't remember certain details, that doesn't mean that it didn't happen. Okay, I think everybody for the most part. Okay. Juror number 10, right? How many times have you thought about that memory?
And I see.
Triggers, maybe?
Yes.
When you get triggers, you start thinking. And do you remember that memory the same exact way every time? Or do you remember certain details sometimes? And then depending on the trigger, you remember more details or less, depending on the trigger. Okay. Have you told anybody else about this first memory that you've had? No? Okay. So for those of you that have certain memories that you all think about or remember, you all normally share it the same way with everybody? No, you're shaking your head. You're number, what's your turn? 68? Do you share it the same way?
Well, sometimes I might remember an extra little tidbit depending on who I'm talking to, the way the conversation's leading, I'll share a little different part of the story.
But I would imagine that the main part of the story
It
is the
stays the
same.
same.
But little details here and there may vary. Okay. How many of you all expect that a witness needs to remember everything? If there are any variations with the memory, you know what? It's just not going to be, it's not enough for me. Raise your number if you expect the witness or the witnesses to have a flawless memory of what happened. Jury number 20? You don't? Okay. Anyone that does? Okay. Jury number 12?
Then no, or afterwards, it happened yesterday.
Okay. Who agrees with jury number 12 that if it happened yesterday, you expect them to have a good memory? Okay. Keep your numbers up. I'm gonna make sure. Jury number 34, 36, 39, 40, or 46. I think I said 36 already, yeah. 72, okay, and 61. Okay, so the parent or guardian factor. So the outcry witness is the first adult that the child tells, okay? So one thing that we forget sometimes is, as a parent, usually it's the parent, sometimes it's someone else. We forget about the parent. Parents are also humans, okay? And if there is anybody else in this world that you love the most and you're willing to give your life for, is who? Your children. So whenever your child comes to you with these kinds of details or allegations, how does a parent react? Is there an appropriate way that a parent should react? A certain way? Jury number 5? You shake your head no. Who here thinks that all the parents are gonna react the same? Like, there's parents that may cry. There's parents that may not react in front of the child and, be the rock, let them know it's gonna be okay. But then as soon as the child goes to the bedroom, out comes the crying. There's parents that might report it to the police right away. And there's parents that might not know what to do. Especially if the one that you're accusing of is someone you really care about, right? What if it's your sibling? What if it's your husband? You see what I'm saying? It's difficult in these kinds of situations. Is there anyone here that is going to hold the way a parent reacted against the child? Raise your number if you feel like, no, you know what, if mom didn't report it, I think I'm gonna have a problem. Because
5 minutes.
if mom thinks, Judge, if mom didn't think it was a big deal,
I'm gonna object to improper commitment question.
Sustain.
how do you all expect? Well, I'll move on because I have 5 minutes left. Police officers. We of course have police officers that may make a report, there might be a detective that might investigate the case. There might be good investigations. And there might be what? Bad investigations. I think it's fair to say that everybody here who works a certain job, there's those employees that are good employees, and there's those that are not so good. And that happens everywhere, folks, even in the most important places, it happens. So what should the state do in cases where there's a poor investigation that was done? What should the state do? Us, meaning us, as in presenting the case or dismissing the case, what do y'all think is appropriate? 14, try to defend the child in what way? Okay. Is it fair to say that maybe bringing the child here to tell you what happened and then you all make that decision? Or should we just say, no, you know what? Sorry, the police didn't do their job, we shouldn't do it, we shouldn't move forward. Who agrees that the case should be dismissed? With a poor investigation? Anybody here feels that, you know what? I just don't think they should be wasting taxpayer money if the police didn't do a good job. How many feel that we should move forward, have the kid testify, have the child testify, and then the jury make the decision at the end of the day? Raise your number if you feel that way. Okay, jury number 10, do you agree? No? Jury number 1, 4, 5, 7, 12, 14, 11, 15 through 21, 22 through 26, 28, 29, 32, 33, 36, 37 to 39, 41 to 43, 44, 46, 52, 53, 54, 55, 42, 63, 64, 66 to 68, 65 too, 69 to 71, 73 to 75. Is there anyone in here that cannot sit in judgment of another because of religious beliefs or because of their beliefs they may hold? Okay, so last final questions, rapid fire. Raise your hand if you have a family, if you know a family member or someone that has been a victim of sexual abuse. Raise your number. Okay. 1, 9, 10, 12, 14, 19, 21, 22, 23, 25, 27, 39, 40, 41, 42, 43, 44 to 46, 48, 49, 50, 51, 53, 55, 59, 60, 64, 65 to 68, 70, and 72. Final question. Raise your number if you or anyone has been or know a family member that has been accused of committing sexual abuse. Actually, let me change that. Let me just change the question real quick. Falsely accused. Falsely accused. Juror number 8, juror number 9, 19, 22, 42, 51, 58, and 65. Okay, looks like I'm out of time at this point, right?
51 seconds.
51 seconds, okay. From those that raised their number on the last question. Raise your numbers again. Is that experience that you know of so profound that you just cannot put it aside and be a fair and impartial juror? If you cannot put that experience aside because it's so profound, keep your number up. Number 9, okay. 55. Anyone else? Okay, well, thank you very much, ladies and gentlemen, for your time. I'm just gonna set up for my co-counsel or attorney here.
Maria, do you need a break? All right, ladies and gentlemen, we're going to take a 5-minute break to give the court reporter a break and so that things can be switched out. So if you all will line up in the hallway, if anyone needs to use the restroom before you run, wherever you see the stairway, on either side, there's a restroom. So you can go anywhere from this floor downstairs. On either side, there's going to be a restroom. And I'll have you all come back at 4:40. All right?
Leave your numbers behind.
Yes, leave your numbers behind.
Don't take your numbers. Don't take your numbers.
Going to the best one.
She's like, get over here. But still.
All right, let's do this. Right for the jury?
There's about 30 minutes then after that. you can-
Yeah, but not for your drawing now.
All right, everyone, please be seated. All right, and ladies and gentlemen, before I turn it over to defense to begin their voir dire with you, could you please stand and state your name?
Ariadna Ramirez.
All right, does anyone recognize the person who's just stood? You do?
Oh, you've been sitting on the.
Okay. All right, other than seeing her outside. All right, you may be seated, thank you. You may see people that come into the courtroom, usually when they come through that door, it's because they didn't read the sign that says we're in trial, don't come through that door. And then the people who are coming through this door are usually staff who have paperwork for me to sign. It has absolutely nothing to do with this case, so don't pay any mind to it. And then you may have people who just want to observe the trial. And you may have family members from either side who wish to come in and watch the trial. Does everyone understand? All right, defense, are you ready to proceed?
Yes, sir.
All right, you may proceed.
Thank you. Good afternoon, almost good evening. How are you guys? Yeah. My name is Matthew Allen, with John Chavez. We're here to represent Raymond Alejandro. All right. Just to get a few things out of the way, this isn't a case of this side is against any abuse of children and this side is for abuse of children. Does that make sense? Right? Sometimes, when I tell people I'm a criminal defense attorney, that's kind of what I get. That's not what we're here for. Obviously, we have the privilege of representing Raymond. And we're here because of a reason. We're here because we firmly believe that Raymond's not guilty. But in this part of the trial, all we're trying to do is find 12 fair and impartial jurors, right? And I apologize, I feel like I'm getting in your personal space over here. So jury service, is this the right case for you? And I'm sure all 75 of you are saying, no, I'm good, thank you. But like Judge Boyd said, it is an inconvenience, but we truly appreciate the time that it takes to be here. All right, I know you guys have other things you'd rather be doing, that you have other things going on, work, school, kids.
whatever it may be. So again, we do appreciate it. But we talk about the duty to serve. Each of you has completed that duty by coming here today, right? A lot of people don't show up. You have completed the duty to serve. Then I'm going to talk about the duty not to serve. Some of you are saying, well, how do I get that? Well, some of you have expressed, look, this is not the right case for me, right? Because of whatever reason it is, personal history, a bias. Because you guys came in here and I said, hey, who can be fair, right? I think everybody would say, yeah, I'm fair, right? So anyone tell me what this is? Anyone?
Oh,
Anyone?
Dallas Cowboys.
Okay, the juror is at, sorry, 40. It's a touchdown. All right. And sir, are you a Cowboys fan? Yes.
I can't hear him, counsel.
Oh,
Could you please
if you
stand?
could stand up and answer. Okay. Anyone have a different opinion? That if it was a catch or not, juror, is it 36?
Obviously not a touchdown.
Okay. And so are you a Packers fan or just an anti-Cowboys? Redskins, okay. That's right. You may need an escort out. Okay, so if I called on juror 36 or juror 45 and I said, hey, you're gonna be on trial to see if this is a catch or not a catch. Do you guys think you might have a little bit of a bias as to that? Yes, right? Okay, and that's all we're talking about. You know, everyone has experiences and history that gives them a little bit of a bias towards something. It doesn't mean makes you a bad person. It doesn't mean you can't be fair and impartial in a different type of case. Just means maybe in this case, it may not be the best for you, okay? So that's all we're trying to figure out. So the presumption of innocence. All persons are presumed to be innocent and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt, okay? We've all heard presumption of innocence. Judge Boyd talked about it, but let me ask you this. Is there anyone in here that came in knowing this is a criminal court, came in and looked at this side of the table and said, I wonder what he did? Right? Nobody? Okay, all right, we got some numbers there. All right, that's natural, that's okay. Now, but the law says all persons are presumed to be innocent. So sitting here today, Raymond is 100% innocent. Does that make sense? Okay. There are some people that say, look, I know that's what the law says, but because he's sitting here, he must have done something, right? Must have done something wrong to be sitting here. It's okay to think that. But is there anyone here saying, look, I understand that's the law and I can almost follow it, but I cannot presume him 100% innocent. I can't say that. Basically, where there's smoke, there's fire. Is there anyone that they fall into that category? Juror 67? Okay, thank you. I appreciate your honesty. So again, knowing the law, you're saying, look, I can kind of, I don't want to put words in your mouth, but you can't fully follow that law to that 100%. Is that fair? Okay. And so, and I appreciate that. Okay, see, he didn't fall out, he's not getting arrested. We just need to know if these are things that you can agree to and follow, and some people can, and there's nothing wrong with that. And so who agrees with juror 67? You could raise your cards. Okay, again, it's knowing that this is the law and saying, look, I understand it, but I just can't follow this one all the way, all right? If that's you, please raise your cards. Okay, we got jurors 8 through 11, 14, 15, 22, 26, 27, 35, 37, 44, 46, 50, 55, 60, 64, 67 previously, 70 and 71. All right. Okay, this is kind of what we just talked about. If they were charged, they must be guilty of something. So let's talk about indecency with the child. So basically, the state went over engaging in some sort of sexual contact with the child. So some people could not fairly serve in a case where a child is the alleged complainant. All right. So if that's you, again, I'm not saying, no, I'd rather not do that. Basically, that there is something that either happened to you, a close friend, close relative, a loved one, something that happened where you would not be able to fairly serve on this jury. Okay, does that make sense? Not just asking who doesn't want to serve. I'm not even asking, have you had an experience that relates to anything like this? I'm asking, is there something that because of that experience, because of the type of case that it is, that you cannot fairly serve on this jury? If you could raise your card. Jurors 8 through 11, 21, 22, 25 through 27, 35 through 37, 41, or sorry, 40 and 41, 44, 46, 50, 55, 60, 64, 66, 67, 69 through 71, 73 through 75. Okay. So the state kind of talked about this at the end, and this, you may be saying, well, you kind of just asked me this, all right? So it's a little bit different though. So the first question is going to be, it's not going to deal with, can you be fair or impartial? Okay. It's just asking, have you, a loved one or a friend, a relative, been sexually assaulted? Okay. If you could, and I'm not going to ask you who or any details like that, but if you could just raise your card. Okay. 9, 10, 14, 16, 19 through 27, 30, 32, 35, 39 through 46, 48 through 51, 53, 55, 59, 60, 63 through 70, 72, and 74. All right. Okay. Now, again, the state asked about false accusations. I'm going to ask, including false, or if it found out to be true, you, a loved one, or a friend, been accused of sexually assaulting a person. You could raise your card. Okay. 8, 12, 14, 19 through 22, 36, 39, 40, 42, 58, 60, 65, 69. Yeah.
Coworker count?
Yes, coworker count 67, 55. Okay, so now that you've kind of had the chance to think about, okay, it's an accusation. Obviously, you don't know the details of it, but you know what the part of the allegations are. So I asked, who couldn't be fair and impartial in a case where a child is a complainant. Now I'm asking for both of these questions combined, right? So you answered if that describes you or a loved one, a friend, a coworker. Now I'm asking if you, because of that experience, because of what you know, that would impact you in this case. You wouldn't be able to decide this case just based on the evidence that you hear, that you would not be able to be a fair and impartial juror. Does that make sense? Okay. So only if that applies to you. You can't be fair and impartial and judge this case based on the evidence. If you could, raise your card.
All right, so I'm going to pause you for a moment. So here's the question. Evidence that's being presented, will you be able to listen to that evidence and base a decision, if you can come to decision, based upon the evidence that you hear? Does everyone understand? Is there anyone who would not be able to do that? Raise your card. All right, counsel.
Okay. All right, thank you. All right, so juror 9, 10, 11, 22, 27, 36, 44, 50, 55, 60, 67, 69, 7. All right, thank you. Again, has anyone ever counseled or volunteered to help victims of sexual assault or children? You could raise your cards. Juror 3, 18, 68. Okay, same. Oh, and
As far as volunteer, working with kids or
yeah,
kids that have been-
well, more of a counseling, not like a volunteer coach or something like that. Volunteer to counsel or something like that. Okay, so the three of you that raised their cards, same question that the judge asked, would you be able to judge this case based on the evidence and facts before you? If any of those three that raise your cards, again, would you have a bias? Or you, because of that experience, you don't think that you'd be fair on this case? Juror 9, and I think you raised your card previously for other things. Okay, thank you. But again, I appreciate it, thanks. I think we covered that. All right, so investigation. They talked about, well, you know, should they just get rid of cases because of poor investigations? Let me ask you this, who gets affected by a poor police investigation? Say juror 18? Everyone? Okay, so, I mean, so you're talking about the person making the accusation, right?
Correct.
And what about, and the accused, right? So, does the investigation matter? Right? There's a reason that we have investigators. If it didn't matter, we wouldn't have them. Would details matter in the investigation? Yes. If CPS were notified, what is CPS, if somebody knows?
Services.
Oh, okay, a lot of people know. Okay, if they're notified, they do an investigation, would that matter?
Yes.
Okay. Would you expect detectives, if someone comes to them and say, hey, John Doe committed a crime against me, would you expect the detective or police officer to reach out to John Doe?
Yes.
Right? Someone tell me why that would be important, why that would matter. Juror 32?
There's two sides to every story.
Okay. So to give them an opportunity to talk, is that right? Now, look, to be fair, does that accused have to talk? No, they have a Fifth Amendment privilege, but should you at least reach out to them?
Yes.
Okay. So these types of accusations, an accusation, in this case, it's a child, so 17 and under, or even an adult. If you're accused of something, if you were accused of indecency with a child, or your family member was, would it be easy or difficult for them to defend themselves? Difficult, juror 7. Tell me why.
I think there's when you involve a child in this accusation, a lot of people immediately think the worst case scenario, right? And it immediately creates some bias. Oh, can't believe he did that. I can't believe, this poor child, right?
Right. Yeah, I mean, that would be a typical human reaction, right? If a child says something happened to them, typically that person who's an adult is gonna want to protect that child, right? Automatically, without knowing details or anything like that. Does that make sense? Okay, so on the flip side, so I mean, tell me why else? Why would it be difficult to defend yourself against that allegation? Yep.
Well, it's difficult to defend yourself regardless, having no, what do you call yourself? Counsel.
Yeah.
With no counsel, it is difficult to defend yourself in any case.
Right, so the state talked about, well, does things happen in a big public place or behind closed doors? Well, do allegations usually happen, somebody did this in front of 20 people, or is it somebody did this to me behind closed doors?
Behind closed doors.
Okay, and that was juror
20.
20? Okay, behind closed doors. So who's there? Who's behind, I mean, taking that as true or not true? I mean, in that allegation, who does it involve? How many people? Two, right? And one person is saying it happened. Another person is saying it didn't happen. In all criminal cases, the burden of proof is on the state. Is that okay with you?
Yes.
Okay, meaning the questions that you have, the burden of proof is the state has to prove the allegations against the accused, right? Why is that? Why does the state have the burden of proof? Okay, a juror, that was juror 32. So innocent, and I'll say innocent unless proven guilty, but yes, you're exactly right. So beyond a reasonable doubt, there is no definition, all right? But we talked about different burdens of proof, okay? So normally I go all the way, I get real dramatic and go across all the way to that side of the room, but I think it'll be a little too close with 75 people in here. Plus I'm already sweating, so that side, no evidence. Then reasonable suspicion, we talked about who got pulled over for a ticket or something, you know, I have as well. Reasonable suspicion, probable cause, what can officers do with probable cause? Anyone? Search, juror number 58, right. They can come into your house at night, they can search, they can make an arrest, okay? I see some of you have been on civil juries. The judge talked about that. Preponderance of the evidence, 50.001%. Right, and we moved on to clear and convincing. Remind me again, who has some young children? Right? Okay, juror one, how old are your kids?
3-year-old and a 2-year-old.
Wow. You really are taking a hit by.
Yep.
Or it could be vacation, I don't know.
No.
I know. But what if the state was trying to take away your children or somebody else's children? How much evidence would you expect them to have in this?
A lot of evidence, I mean, you know, to prove, you know, you were guilty.
Right, that is a serious allegation, right?
Yeah.
Serious consequence of having your children removed and taken from you. How many have agreed? Yes, that it better bring it, right? Then in a criminal case, it's even further, beyond a reasonable doubt, right? It's the highest burden that we have. Why is the burden so much higher? Why is it so high in a criminal case? Juror 72?
What's the conviction?
I can't hear, counsel.
Oh, if you could stand up, sorry. No, you're good.
Yeah, once the conviction is done, it's said done, so whatever gets sentenced is, it's what it is, there's no going back.
Right, so if somebody is convicted of a criminal offense, what types of consequences are we talking about? Juror 20, what'd you say?
Jail.
Jail time, right? We're talking about someone's, they're talking about sex offender registration requirements, prison time. We're taking away someone's freedoms and liberties, right? Does anyone have a problem says, okay, if the, say, well, look, I understand that's for most criminal cases, that's fine for a theft or something else. But if the case involves a child, it shouldn't be beyond a reasonable doubt. Does anyone think that the burden of proof should be lower because a child is the complainant in the case? No? Okay, it's okay if you do. Juror 46. You do? Okay. So, and I appreciate you speaking up. So, so again, you're saying, look, for most cases that's fine, but for you, beyond a reasonable doubt, it's too high for a case involving a child. Is that fair?
Yes.
Okay, thank you. So 3 possibilities in a criminal case: not guilty, guilty, and I don't know. If it is I don't know, if at the end the state has presented their case, you're back in the deliberation room, and you're thinking, man, I don't know. Maybe, probably, could have. I don't think so. I don't know. What does your verdict have to be? Not guilty. Why?
You come to a decision that he's guilty beyond a reasonable doubt.
Right, does that make sense? Okay, so let me ask again. So we got not guilty, guilty, and if you're back there and you're saying, man, I just don't know. What does your verdict have to be? Oh, kind of gave away a lot of the answers there, but so what are some, go ahead and look, but I guess tell me why. What are reasons to accuse somebody of this? And you can expand on it if you want, right? They obviously they committed the act, right? What about revenge? You want to get them out of your life. The person is seeking attention. The child in this case may have something else going on. Someone else is putting you up to it. Do we always know why somebody is making an accusation? Okay. And who's the only person that can tell you why they made that accusation? The accused. Okay. So again, the state talked about, okay, well, children wouldn't want to do that. Children, if a child is making an accusation, do you think they're always thinking, okay, if I say this, then the police are gonna come. And then if the police come, then I'm gonna have to go to court to testify. And then if I go to court to testify, I gotta talk about these details. And on and on and on and on. Do you think children are thinking about that before they make up a lie or they make up an accusation? No. Some, I mean, some might, to be fair, right? But do we think that some kids or some children may say something and then they're not really knowing what's coming next? And what do I say? What do you think I mean when I say like the ball it's rolling too far downhill, right? Yeah, juror 72.
Like in the case of this, if that's already out in public, people are gonna kind of keep that image of someone forever, even if it is.
Right, and so, and we talked about, well, depending on if it's a brother or cousin or a husband, right? If you throw that out there, do you think it's gonna be easy to take it back? Right? That could be difficult, and not just for children, but for adults, right? Yeah.
When you say child, what's the date range you're talking about?
Basically like 17 and under, yeah, so you're not knowing if it's and that's a good point. Is it a 3-year-old? Is it a 16-year-old? It's a big age range, right? And I'm not asking you to decide like all children don't realize what they're doing. So when I say that, it's just some may and some may not, and that's for you to decide their credibility, right? But that's a good point. I mean, that's obviously like 3 to 16 is a huge age difference depending on what we're talking about. Do children ever lie about something important? Right. Do you always know if they're lying? Now with your kids, you may think like, okay, I know a little bit more. I know with my 7 and 4-year-old, I think I know more times when they're lying, but they still trick me sometimes. But can it be difficult to determine if they're telling the truth or not? And again, depending on the age, do they understand the impact of what they're saying? Okay. And once that ball is rolling downhill, even if they understand the impact of what they're saying, what do you think, at least, what would you think if you're that child, if you say, oh, well, it didn't happen, or I lied? Who's gonna get in trouble? The accused. Well, yeah, if the child then says, no, it didn't happen, do you think that child thinks, uh-oh, if I tell them I was lying, you're gonna get in trouble, right? Okay, we talked about what do kids want? They don't want to get in trouble. Does anyone believe that a child would never lie about being sexually assaulted? I'm not talking about your child or your niece. I'm talking about any child, right? Does anyone say, no way? There's no way any child ever in the history would lie about that. Anyone? Okay. Again, I asked you, do we always know why someone would make an accusation? We talked about the burden of proof is on the state. Is there anyone that you would require the defense to affirmatively show you, you got to show me why? What's the ulterior motive? Why did they lie, right? Do we always know? Oh, sure. Oh, okay. Right to silence. So if the person on trial doesn't testify, you cannot hold it against them. You can't refer to it or allude to it, okay? The flip side. So we talked about why someone wouldn't testify. Might be advice of counsel. It might be because they're not great at answering questions. If you've noticed, I shake my leg and I bite my nails. 2 things that show you I wouldn't be a good witness, okay?
5 minutes.
Thank you, Judge. Jerry Seinfeld said the number 1 fear in life is public speaking, and the number 2 fear is death. That means if you go to a funeral, you're better off in the casket than giving the eulogy. A lot of people have a big fear of public speaking. Okay, just like an accused, when they get up there, they don't want to talk about it. Do you think somebody else? Do you think the person who is making the accusation doesn't want to talk about it? Do you think the person accused of it wants to talk about it? Right? It's uncomfortable. Now, let me flip it, the right to testify. So if somebody chooses to testify, you have to start them all at the same level. All right, you can't say, look, the only reason the defendant would testify is to get himself out of trouble. I'm not gonna believe a word they say. Okay? So is there anyone that would automatically disbelieve that person? Or let me ask it a different way. Is there anyone who would automatically start the defendant out at a lower level than all the other witnesses? Does that make sense? Is there anyone? No? Okay, so we'd start everybody out the same? Okay, fair enough. I'll ask it again. Is there, like Judge Boyd asked, is there anyone who would hold it against the defendant? They would say, look, I gotta hear from them. Whether it's this type of case or any case, that they could not put that out of their mind, that they're gonna use it in some form or fashion if the person does not testify. Anyone? Okay. So your job, you are the judges of the credibility of the witnesses, okay? So you get to decide to believe some, all, or none of someone's testimony. Judge Boyd will give you the job, the law. Is there such thing as a human lie detector?
No.
No, okay. I know some TV shows like to think that there are, but is it possible for reasonable people to disagree on what they believe happened? Okay, two people can see or hear the same thing and one person can say, yep, I believe it. The other person can say no. Is that fair? Do details and consistency of details matter in testimony?
Yes.
Right? Why? Why would it matter?
Because if
The only
it doesn't,
evidence
then
we have.
it could potentially not have happened.
Okay, juror number 24, say it again.
Because if it doesn't line up consistently enough, then potentially it never even happened in the first place.
Okay, and you said consistently enough. I know we talked about, well, I mean, tell me like how close are the details, right? Did he say light green shirt and it was a dark green shirt? Like, all right, that's one thing. But forgetting about, and it happened another time, or oh yeah, everyone was home. I forgot. No one was home, right? Details matter in consistency, or consistency of details matter for credibility, right? And again, it's up to you to determine, all right, look, that lined up pretty well. I find that person credible, or no, that didn't really line up. That doesn't make sense that you couldn't remember that. I don't find that person credible. Does that make sense? Okay. Speculations, assumptions, guesswork, fill in the gaps. The only gap, okay, if you have a question at the end saying, man, I wish I would have known this, you have that gap. The only thing you fill that with is the presumption of innocence, because that means that the state didn't meet that burden, didn't answer that question, okay? Range of punishment, I'll ask question. So probation is possible if the person has no prior felony convictions, you've sentenced them to 10 years or less, and the child is 14 years or older at the time, okay? So those three conditions have to be met. And obviously there had to be a conviction. If you're wondering why I have to ask it, because I have to ask it now, okay? That's the way the law states. So is there anyone knowing those things that still would not ever, under any circumstance, be able to consider probation in this type of case? Okay? So if you cannot consider probation at all, I'm not saying you have to give probation, I'm saying if you can't even consider it, please raise your card. 8.
All right, so just one moment. I'm going to pause you for a second. The range of punishment is anywhere from probation to 2 years up to 20 years. So you have to internalize that that's the range of punishment. Does everyone understand?
Yeah.
And then if you were to find someone guilty, you should be able to, if you can, look at those facts and apply those facts to whether or not you think someone is entitled or you think they should receive probation. Does everybody understand?
Yes.
For example, people will say, you know what? A murder case. The range of punishment is 5 to 99 years or life. People will tell you sometimes there is no way I'm considering 5 years for murder under any circumstances. And then when you give them a hypothetical, because sometimes you can't think of hypotheticals, but in a murder situation, if I give you a hypothetical that they're high school sweethearts, the guy always knew since elementary school that he was going to marry that girl. He was pulling on her pigtails in school, and he's always liked her. And he told his family, that's the girl I'm going to marry. They end up getting married. They spend 40 beautiful years together. She ends up developing a terminal illness, or he develops a terminal illness in great pain. The doctors say nothing we can do, and they're going to be in pain. And that person begs them, please help me end it. And they save up pills. They give that person pills so that they can take it and so that they can be put out of their pain. That's murder. Could anybody consider the minimum of 5 years in that situation? The same thing with this case, these type of cases, the range of punishment is anywhere from 2 to 20 years or potentially probation. Let's say the person who's being accused is 19 years old or 20, and the other person is 16. That's a situation, right? Is there anyone here who wouldn't be able to consider probation in that situation? All right, thank you. So raise your card. All right, you may proceed.
Okay. So again, knowing that there's lots of different scenarios, if these are met, you would not, under any circumstance, any scenario, be able to consider probation. If you could raise your cards. Okay, here's 8, 9, 11, 15, 22, 37, 39, 40, 41, 44, 60, 63, 66, 67, 69, 70, 72, 73, 74.
All right, that's your time.
All right, thank you, ladies and gentlemen.
All right, I'm going to have you all step outside. Please leave your cards behind, and please do not leave them outside because we may call you back in.
What is this?
5:50. 5:50.